Well, good morning, everyone. This is George Spees with the Pennsylvania Office of Open Records. Welcome to this morning's webinar, where this is the second one for this year, and we're going to be talking about basics of the right to know law. It's always a good session for people who are new to the right to know law. You might be an open records officer. You might be a manager who's been assigned open records work, or you might just be a member of the public who's curious about how this law works and what your rights and obligations are. But I recommend it for everybody, even as a refresher every now and then. I think it's useful just to come back to the basics and get an understanding about, what the right to know law involves. So that is pretty much our goal this morning. A couple preliminaries. First, if you've never sat through one of these webinars before, it's basically a PowerPoint, pardon me, a PowerPoint presentation with me speaking in the background. The PowerPoints are on the Office of Open Records website, and the URL is on your screen right now. Go to the training tab and scroll down, and you'll be led to the PowerPoints for all of our presentations. And you're free to download those and use those as you see fit. Maybe for future reference for yourself, maybe you want to do local training. Maybe you have a colleague who you think would benefit from having the PowerPoint. It's there for you to use. Also, this session is being recorded, like all our sessions are. And the recordings are available if, again, for the same reasons, you've got a colleague who wasn't able to attend this morning. Maybe you'd like to do your own localized training. But what you can do is send an email to our office, and they will provide you with a link to a file sharing service that gets you into the recording. If for some chance, like say your information technology people have put in some security measures that don't allow you to access file sharing, the alternative would be to send us a flash drive in with a self-addressed stamped envelope and a note indicating what recording you want. And someone here will be happy to copy the session from today over to the flash drive and mail it back to you. Usually that's about a week turnaround, with the mail and everything, and, getting it on our radar screen to come in here and make the copy for you. But we're more than willing to do that. Okay. Then I want to talk about questions. This is a live session, obviously. But we want to help you out with any questions that you might have. So a couple ground rules. First is that we are talking about basics of the right to know law. So your questions should be about that, about the right to know law. Second is that if you can keep your questions as succinct and brief as possible, that's also helpful. Sometimes folks will type out a couple paragraphs, and it's just awkward for me to sit here and read it while everyone else is waiting patiently to, wait for me to get through it. Usually what happens is that if you've got a situation unique to your agency or your right to know requests, I'll do one of two things. We'll wait until the end of the presentation and I'll come back to it, or we'll take the conversation offline. Again, the information's on the screen right now. You can reach out to our office. There's administrative staff here who are very good at answering questions. And if they can't, then they'll forward your contact information to one of senior management here, and someone will get back to you. Again, a fairly quick turnaround. We realize if you're contacting us, chances are you're up against a deadline of some sort, and we want to help you out there as much as we can. We can't provide legal advice. We can't answer requests for you. We can't tell you how appeals are going to turn out. But there is a wealth of resources available that we can kind of get you steered in the right direction and hopefully solve whatever problem that you have. Okay, so I think that pretty much covers it. Let's dive into the presentation now. And I always like to begin with a fundamental statement. What's the right to know law all about? Because a lot of times, if you find yourself confused Or if you find yourself, let's say that you're an arrow and an open records officer facing a situation where you're just not sure which way to turn. I have always found it very helpful to come back to this fundamental statement about what the right to know law is all about. For starters, the whole purpose of to why the right to know law was written was to grant the public access to ensure government transparency and just overall good responsive government. But what it's critical to remember is that the purpose of Pennsylvania's right to know law is to give the public access to public records. That's what the law is all about. There can be a common misunderstanding when you see that term right to know that some folks think, and really this is on both sides of the equation, requesters and agencies, that they think the right to know law is some sort of Google where the public can ask any sort of question and it's the agency's responsibility to run around and find an answer to that question. Obviously, that's not the case. So when in doubt, always go back to this fundamental statement that it is to give the public access to public records. No more, no less. So there are some basic legal precepts to keep in mind when looking at this fundamental statement. And the first is that your starting point is that every record of an agency is presumed to be public. Okay, everything, and when I use the term agency, we're talking about any government entity. At the state level, it would be departments, commissions, boards, authorities, and the like. At the local level, you're talking cities, boroughs, townships, school districts. As an extension of school districts, it would be public charter schools, public universities, uh, also any public authority created by statute would be considered an agency. So I use that term in a generic sense. But every record that they have in their possession is presumed to be public. And then if an agency believes that a record is not public, it is the agency that bears the legal burden of proving that it is not, that it should not be released into public domain. And while that sounds like a rather daunting statement, there are tools available both within the right to know law and with other laws that can make a record confidential. Okay. But you can't just say, well, this is none of your business. This isn't public. You have to show that either provision of the right to know law or another law that deems this record as confidential in order to meet your legal burden. Okay, so it's not just when you first get a right to know request, if it raises a red flag there where you're thinking, I don't know, I don't think this should be public, chances are it's not going to be that difficult to support it legally. It's just that you need to reference that legal terminology or provision in order to support the denial of access to those records that you're going to ultimately give to the requester. Okay, so you do have that legal burden. Even if a record should not be released into the public domain, if you fail to meet that legal burden, you could lose your appeal and be ordered to release that record. Okay, and you don't want that to happen. Okay, and unfortunately, it happens too much. Okay, so that's the foundational elements of what the right to know law is all about. Let's get into some more specifics here. Okay, and one of those is the fact that the right to know law is not a confidentiality law. Okay, what does that mean? Well, first, you can give records out to the public, okay, without ever referencing the right to know law. So for instance, let's say it's budget season and I come into your office as, a member of the public and I ask for a copy of the budget. You happen to have a stack of them there on your desk. You can simply hand me a copy of the budget. there's no requirement that I should have a right to know request in order for you to give me a copy of the budget. Okay, you see how that works. Now, at your discretion, if the agency wants to, they can establish a requirement that we will only give out public records in response to a right to know request. But to me, that seems rather bureaucratic. I'm not sure why you would want to do that. But you can give out public records without ever mentioning the right to know law. What many agencies will do is use social media to post right to know or post public records that are commonly requested, such as budgets, contracts, salaries, and purchasing documents. We view that as a best practice because what will happen? Well, first offhand, if you're joining us today and you work for an agency, take a look at right to know requests that your agency receives and identify trends. What are people asking for? Then take those records and put them on your websites or wherever so that they're readily available. And a couple things will happen. First offhand, the public is very responsive to this because they would much rather sit in the comfort of their family room on their computer and search your website to find the records that they need or that they're interested in. The second thing that happens is that the hits on your website start going up because it's no longer a billboard. It's now a business document, okay, because you're putting public records on your website. Thirdly, you'll note that the right to know requests start going down because now people don't have to submit right to know requests to get the public records that you've put on your website. So it really makes your job easier. Maybe a little more work up front to develop your website, to upload the documents that people are requesting, but that is much easier than having to respond to the same right to know requests over and over again for the records that people are asking for. Okay, so it kind of makes good sense in the long run. So take a look. What are the most commonly requested public records that your agency has? Load them on your website. Then the next time you receive a right to know request, and the right to know law allows this, rather than providing the record, all you have to do is provide the URL for your website and where they can find a copy of the public record that they're looking for. And some records are inherently public by nature, like I have on the screen right now: budgets, contracts, salary information, purchasing documents, okay? There is no debate that these are public records. So there's no fear of releasing information that you shouldn't. Put them on your website, make your job easier, make it more responsive to the public, and you've got good government going on. Now, back to right to know requests. This is something that a lot of people don't realize as well. Let's go back to that budget example that I used. Let's say I come walking into your office and I have a right to know request and I'm asking for a copy of the budget and you've got a stack of them there. You can say, George, you know what? If you tear up that right to know request, I'd be happy to give you a copy of the budget. And you're saving yourself a lot of work and you're saving me time because it could conceivably take you up to 35 days to provide me with a copy of that budget. So why wouldn't I agree to that? Okay, you're saving yourselves work and you're not violating the right to know law by doing that because everybody's happy. We're getting what we want, okay? Now, if for some strange reason I would say, no, I want to follow the right to know process, then you have to do that, okay? But there's absolutely nothing wrong with having that discussion with me, saying, look, I'll give you a copy of the budget. Just withdraw your right to know request and everything will be fine, okay? The right to know law allows you to do that as well. You're going to find that the right to know law affords agencies a great deal of flexibility in how you manage your open records program. Okay, moving on. An agency, I'm presuming you're here if you're from an agency, that your agency is subject to the right to know law. So there are some obligations that you must do. The first, and probably the most important, is to appoint an agency open records officer, what we call an ARO. This is the person responsible for receiving right to know requests, for processing them, and ultimately for responding to them. Okay, there is, some legal, I want to say a legal liability. Okay, that comes with this role. Okay, you are responsible for this critical function. Um, As far as, who the arrow is, the right to know law only requires that it be either an employee or official of an agency, uh, meaning you can't have a volunteer member of the public serve as your arrow. It could be, a mayor, it could be the president of council, or it could be the administrative assistant who greets you when you walk in the front door. School districts, you can find a school district where, again, it might be the nice lady in the administrative office who is at the counter when you walk in, or it could be the school superintendent. There's no specific requirement as to at what level that the arrow exists within an agency. An agency can also have more than one arrow. You could have one borough where they have one arrow that covers all facets of the borough operations. You could go 3 miles down the road to the next borough, and they may have two. They might have one arrow who covers the administrative side, and a second arrow who covers law enforcement, the police department. And that's fine, as long as it's clear to the public when they come in with their right to know request, who do I give this to? Who's the appropriate person? Okay, that needs to be spelled out and clear. Agencies can also come up with their own rules for managing their open records program, as long as it's not in conflict with the law or any policies or procedures that have been promulgated by the Office of Open Records. I'll give you an example. Within the right to know law, there is a provision that says agencies may accept anonymous requests. There's another law in Pennsylvania. It's known as the Statutory Construction Act. And to paraphrase here, basically, because the right to know law has that word may in it, it also means may not. So, breaking this down into English, the right to know law essentially says that an agency has the discretion to say you will not accept right to know requests that are anonymous, that the person must identify themselves, okay? And that's up to you at the agency level, whether or not you want to adopt that kind of practice, okay? And you'll find, like I said before, all kinds of flexibility in the right to know law as to how the agency is permitted to manage its open records program. You can come up with your own form, and most agencies do. They like to have their seal at the top, perhaps contact information for the arrow. Maybe they list any of those local rules that they have. Maybe they list cost information. It's really up to you. Many agencies will also link to the state form. Okay, and if someone comes in with the state form, you must honor that, okay? But that's on our website. There's not necessarily anything special about it. You can check it out, and if you want to copy certain features from it, yeah, go ahead, have at it. Okay, but remember, in addition to your own form, you must accept the state form. And again, there's no requirement that you use any form at all. If you want to allow it, someone can come in with a right to know request that's handwritten on a piece of tablet paper. Our office, believe it or not, we have accepted right to know requests that have been written on the back of napkins. Okay, it's really up to you as to how you want to manage this. But remember, uniform request form, you must accept that. And then we also ask that you notify the Office of Open Records who your arrows are. On our website, we maintain a searchable database with all the arrows, or at least we try and get all the arrows for the state on there. It is pretty much a voluntary process, and we realize people move on, they get promoted, they retire, but you want to make sure that your records on our database are up to date. Because number one, we'll get inquiries. Hey, I want to file a right to know request with this township, but they don't have anything on their website. Do you know who the arrow is? Or if we get an appeal for your agency, we go to the database to reach out and notify that person that we now have an active appeal. So it's important that this be kept up to date. Okay, question has popped up. Is there an updated fillable form with the new right to know fees included? I'm not sure whether the fees are actually on the form itself, because that can vary based on the nature of the response. So my initial answer is no, you're not going to find something like that. There is a fillable form on our website, though, so that if you wanted to, I think you're going to find both. Now, I haven't checked it out for quite a while, but I think you're going to find both. One is a printable form that you would fill out, using a pen. Then there's also a version where I think if you wanted to file a right to know request with our office, I know that that is a fillable form. Whether or not we have one that could be downloaded, I'm not sure of that, Ginny. I would have to check that, and I apologize for not having looked at that for several months. Okay, but maybe you want to check that out. It would be on our website if it's anywhere. Okay, moving on from obligations, is there always a fee? No, not necessarily. Okay, as far as fees go, you're a little ahead of me, but on our website, there is a fee schedule. And whether or not there is a fee is dependent on the nature of the response. Okay, so I cannot give you a black and white answer. It depends on what you're asking for, and in some cases, the steps that the agency takes in order to fulfill your request. But you're going to find the fee schedule on our website, and I'll talk about that here shortly. Okay, another one has come up. I have an individual who requests right to know, and they always refute and say, hello, there's nothing in the state statute requiring that I fill this form out. This form does not supersede my request. I reserve all rights. They attach a letter with their request and not a form. Okay. You can require that a form be completed. Okay. That is at the agency discretion. And I think that there is case law to support that, but I'm a little hesitant to say that definitively. You can, at your discretion, accept a right to know request that is not on a form. Okay, but I think we have case law that supports the agency's right to require that a form be used. Okay, so I'll go that far. I think that's accurate. Okay. As far as the person disputing that, I think at best they could file an appeal if you deny it because it's not on a form. What I would recommend is going into our final determinations database, which again is on our website. It's searchable, and just search on that particular topic on, right to know form or something like that. And I believe that all the appropriate final determinations that I'm thinking are out there will come up and pretty much support what I'm saying. But I'm 99% confident in telling you that the agency has a right to require that a right to know request be submitted on a form. That's, again, part of the flexibility that the right to know law affords you. Okay, good questions, folks. Keep them coming. Okay. Okay, so let's move on to, again, obligations, and this comes out to postings. Okay, now, you're not required to have bulletin boards. You're not required to have websites, but physically at your place of business, you're required to have information on the open records law. Also, if you have a website, right to know law information must be posted on your website. The whole purpose of having the postings is to educate the requester. My experience is the more information you can put out there about the right to know law, how it works, what your requirements are, the easier the process will be. People don't like surprises, okay, because that throws hurdles in front of them that they're not expecting. They get frustrated, they get upset. So if you can use your social media and postings to educate folks as to how the process works, they'll be happy, you'll be happy, you'll save everyone a lot of work, a lot of headaches, and it just works out better in the long run. So you need to have contact information for the arrow. Who is the arrow? How do I get a hold of them? How do I get them this right to know request? You need to have contact information for the applicable appeals office in case the agency denies their request, okay, because they have appeal rights. In 90, let's say 95% of the cases, the appeals office is going to be the Office of Open Records. So um, you would use our URL for our website because that's the easiest way to file an appeal. They can file directly on our website, so I just recommend you use that. You need to have a form available, whether it be your form or the state form, if you require it, for them to fill out for the appeal, or I'm sorry, for the request. So if they come in, they don't have a form and you require one, you would have a blank form available for them to fill out. And then any of those local regulations that you might have promulgated, you want to have that out there on your website and your postings, again, so that people know what the playing field looks like before they enter the game. You want to make this as easy as possible for them to access public records. Okay, and that'll work for you then. That'll save you a lot of work in the long run. Okay, there are some things that you cannot do with the right to know law. So let's talk about those real quick. The first is that you cannot limit the number of records or the number of right to know requests that a person submits in any specific time frame. You can't say to a lady, I'm sorry, you've already submitted 3 right to know requests. That's all we allow. If she's inclined to file a dozen right to know requests this week, the law allows her to do that. Now, I'll just go off script here a little bit and say that if the majority of folks who are filing right to know requests are doing it for legitimate reasons. They have a need for a public record, so they file a right to know request in order to access that public record. And they're willing to pay nominal fees to do so. However, we readily admit that there are a handful of people out there who have weaponized the right to know law. For whatever reason, the relationship between your agency and that person has broken down. They've decided they're going to be a pain in the neck, and one of the ways they're going to do that is by filing frivolous right to know requests. Okay, there are ways to deal with those people. My experience and my recommendation to you is to attend the right to know request that we do on payment issues. That might be coming up or the right to know webinar that we do on payment issues. That might be coming up in 2 weeks. I'd have to check the schedule, but I think it's out there for 2 weeks from now. And this is because, like I said, legitimate requesters are willing to pay a nominal fee. Problem requesters usually aren't willing to pay any money to be a pain in the neck. Okay, so attend this right to know webinar on payment issues, and I think your eyes will be opened. And if you happen to be attending today from the public side and you're one of these problem requesters, well, shame on you. Okay, but it wouldn't hurt you to take a look at this so that you know where we're coming from, and hopefully things can get healed up between you and whatever problem was created. The other thing that you cannot do is compel a person to tell you why they are filing a right to know request. You cannot deny a right to know request based on the reason or what you think that reason may be, even if you think they're filing the right to know request just to see you work harder. Okay. That's just the way that the right to know law is written to protect the rights of those who are seeking public records. I like to define or describe the right to know process as an obstacle course. And you've got the start, which is a matter of receiving the requests. Then you've got deadlines, which are kind of like time standards that are built into, if you want to enter this race, you've got to show us previous ability to complete the race or the course within a certain time standard. So there are your deadlines. Then you've got on this course, you've got two hurdles. And in front of the second hurdle, you've got three hoops that you have to run through. And it's only after you make it over the second hurdle that you get the records that you're asking for. So that's kind of where we're going to go for the next several slides in describing this whole process. So the start is receiving a request. Once the arrow receives a right to know request, the first thing that they have to do is note the date that you receive it, because once you receive the request, a deadline kicks in. And the first deadline is that you have 5 business days in which to provide an initial response back to the requester. And it's 5 of your business days for the agency. So you may not be a Monday through Friday operation. Let's say that you're a small township and you're only open 2 days a week. Well, the 5 business days, let's say you receive the request today. The 5 business days conceivably would be tomorrow, Thursday, Friday, and then you would go to next week, Thursday, Friday, and then you would go to the third week, Thursday. So the end of that 5th business day would be your 5 business days. Darby's question, yeah, okay, so I just answered your scenario, 2.5 weeks. Okay, you're reading my mind here. All right, so it's your business days. Let's say you're a school district and during the summer break, you're only open 3 business days a week. Okay, that would apply. Let's say you're closed for a holiday. Holiday is not a business day. Let's say that you're closed for a snow day. Snow day is not a business day. Let's say you're a police department, 24/7 operation. It would be those days in which your business office is open for the public to come in and conduct business. Okay, some questions have popped up here. Yeah, you did type too fast. Okay, I am the arrow on vacation. Does it apply to me when I come back? Yes. Okay, Sue, the way the law is written, it says when the record or when the request is received by the arrow. And there is actually a Supreme Court case out there that supports this. It is Donahue versus the officer of the governor. And that's exactly what happened. The arrow was not in the office. There was a delay before they got it. And the court says, the law says, once the arrow receives the request. Now, in this scenario, what I recommend is that, like on your email, have an out of office reply that lets people know you're not available, because you don't want confusion as to when the deadlines start. Because let's say you're on vacation, 5 business days go by, the person doesn't hear anything, so they file an appeal. Well, that appeal is premature. And again, they're going to be frustrated. So let the person know. If you can have someone answering your emails for right to know requests, to let them know that the arrow is on vacation, when you'll be back, when they can expect the clock to start ticking, that's helpful. Okay, next one is a part-time secretary is our arrow. How will that work if she is only here certain days? Again, it's when, well, that's a good question. Business days are when the office is open for business. Okay, so if by chance, if the office is open full time, but the arrow is only available part time, it's based on the office business days, not the arrow's schedule. However, if the arrow is on vacation and she doesn't get the request until she returns from vacation, Those are not business days, okay? So it's kind of a combination of the office business days when it's open for the public to come in and do business, and also when the secretary is available. I know that's a little confusing, but that's how it works. Okay, and the other question looks like I've answered that. Great. Okay. Hey, these are good questions, and they're good basic questions, which, is the purpose of this session today. So keep them coming. Thank you. Okay, if there is a deputy arrow, does that impact the business day test? Yes. And if you can have an alternate arrow to fill in when the main arrow is going on vacation, that is awesome. Okay, if you can do that. Now, I realize many offices, you're one person deep, you don't have that luxury, but if you can appoint an alternate or a deputy, please do so. At the very least, they can respond back to the requester to let them know that the regular arrow is out of, they're on vacation, and that, maybe if it's necessary, you take the 30-day extension, which we'll talk about here in a minute. Okay, now, how long should we keep the request and any associated materials with the right to know request? If you look at the right to know law, it says maintain a copy of the request for 30 days or until all appeals have been exhausted. Okay, appeals. A person will, under certain circumstances, they have the right to appeal, and that appeal process can actually take several years if it should happen to go up through the court systems. Okay, so it could be you hold on to everything for, several years. And typically your solicitor would be involved at that point, and they're keeping the records available, but you should also keep those records available too. If no appeals have been filed, 30 days. After 30 days, it's pretty safe to dispose of everything because the person will no longer have appeal rights after 30 days. However, in Pennsylvania, there is a second law that you need to be aware of, and it is known as the Pennsylvania Municipal Records Act. That act, which is promulgated by the Pennsylvania Historical Museum Commission, Bureau of Archives and History State Records Center, recommends that you keep all right to know materials for 2 years regardless. I would recommend that that's the law you should follow, okay? One of two factors. If it's under appeal, keep it until all appeals have been exhausted. If it's not under appeal, keep it around for 2 years. Now, the Municipal Records Act only applies to municipalities such as cities, boroughs, townships, and the like. It does not apply to school districts. But still, if you're from a school district, my recommendation, now this is not the law, but my recommendation is 2 years. There is no comparable Records Act for school districts. Okay, it just isn't out there. So you can take a look at the Pennsylvania Municipal Records Act, which you'll find on the Museum Commission's website, and maybe use that as a general guide, not as a legal doctrine, but as a general guide. It may prove helpful. But we've checked with, the School Boards Association and some others, and there is no retention schedule out there for that for school districts. Okay, moving on here. Extensions. Okay, can you give us an example or sample case for an appeal? Yeah, I'll talk about appeals towards the end of the presentation. We'll get in there. Is there a recording requirement for how many types of right to know requests? No, Sue, there is not. There is no central reporting mechanism for right to know requests. Like, you don't have to send in an annual report, but it is good to keep track of this for your own metrics, to follow trends and so forth. Here at the Office of Open Records, the workload is increasing exponentially with appeals and right to know requests. They had been holding steady at like 1,300 a year, but I think this year they're going to break the record once again. Just more and more right to know requests coming into our office. So we suspect that you're experiencing the same, but there is no central reporting mechanism. Okay, I'm going to go back to talking about deadlines, and the next one is extensions. Let's say that for whatever reason, you cannot provide a final response within that 5 business day threshold. The right to know law now allows the agency to take a 30 calendar day extension. But in order for the extension to be valid, there are some requirements that have to be met. First, notice I'm distinguishing between a business day and a calendar day. Okay, a calendar day would include Saturdays and Sundays. It would include holidays. It would not give an arrow an extension because they're on vacation. You look at your calendar and you simply count out 30 days. Then that would be the end of the extension. Now, for the extension to be valid, first offhand, it has to be taken within the 5 business day window. You can't wait until what would otherwise be the 6 business day, say, oh my gosh, I forgot about this right to know request. Well, we'll just take the extension. Unfortunately, you've denied the request by default, and the person now has appeal rights. Okay, it's what legally is known as a deemed denial. Next, you have to notify the requester in writing that you're taking the extension. And if they submit the right to know request by email, you can just email them back, hey, we're taking the extension. Then you have to tell them a reason why you're taking the extension. And you can go to section 902 of the law and it lists 6 reasons. Okay, and it could be that we keep these records off site and it's going to take us longer than 5 days to go check out what we have. Or our solicitor wants to review our response to make sure we're not giving out anything we're not supposed to. And that's going to take longer than 5 days. Okay, you choose the reasons that are applicable for this particular case and you include that in the notice of extension. Then you provide a date as to when the person can expect to get your response. Typically, it's on the 30th day of the extension, okay? And then an estimate of any costs they can expect to incur for your response. It is just an estimate. It's not a hard quote. Sometimes it's a little high, sometimes it's a little low, but you settle up on the exact amount when it comes time to actually provide the records to the person. So to kind of summarize here, you've got your 5 business days and then the 30 calendar days of the extension, if you choose to take it, get tacked on to the 5th business day. 35 days, if you will. Now, don't get into the habit of automatically taking the extension if you don't need to, because that upsets people. If it's clearly a public record and they're readily available, like budgets, like salary information, like contracts and so forth, get it to them or get their response out within the 5 business days that you're granting their request, okay? Because that's easy, all right? It's easy, and you shouldn't have to take a 30 calendar day extension for something that is obviously a public record. Now, let's talk about these hurdles, and here is the first one. We have to answer the question, is it a record? Okay, notice, is it a record? Now, anytime you're confused about a law that you're looking at, let's say the verbiage is vague, let's say maybe there appears to be conflicting language in there, I always tell folks, take a look at the definitions section, because invariably that will clarify whatever the issue is that you're having trouble with. And sure enough, you want to know what a record is, go to the definition section in the Right to Know law, and it tells you a record is any information, regardless of its physical form or character, that documents a transaction or activity of an agency and is, et cetera, et cetera. Okay, key phrase highlighted here, documents a transaction or activity of an agency. So when we come up to this first hurdle and we have to answer the question, is it a record? What it's saying, to kind of translate this into English, is that does the document reflect the mission of the agency? Is it about what the agency does? Okay, well, you're saying, well, why wouldn't it? Well, all day long, we generate communications that do not rise to the definition of a record. Some examples. I send an email to one of my coworkers. hey, I hear a new restaurant's opened up downtown. Let's go down there for lunch tomorrow. Or what do you think the chances are for the Eagles this Sunday? Or I'm picking up a gallon of milk on the way home tonight. Okay, all common communications that I might send during the course of a business day, but yet have nothing to do with the agency. Thus, they do not meet the definition of a record per the right to know law, and they don't make it over the first hurdle. They're off the course. So I don't have to worry about communications like that being released in response to a right to know request, okay, because they're not records. Okay, I hope you understand that. They do not document a transaction or activity of an agency. Now, let me turn this around a little bit and tell you what could be a record. Let's say I'm a public official, a township supervisor. I'm at home in my family room. I'm on my personal computer. I'm on my personal Gmail account, but I send an email to one of my colleagues on the board of supervisors. Hey, I hear tomorrow night this proposal is coming up to revise an ordinance. I got some trouble with it, and here's my thoughts. What do you think? All right. Well, that does involve documenting a transaction or activity of an agency. The fact that I'm on my home computer, on my personal Gmail account, does not in any way remove that record from the public domain. Okay, you cannot use personal devices and personal accounts to hide the public's business. It would still be subject to the right to know law because it is based on the content of the record, not how the record is created or how it is sent. Okay, I received a request asking for information, but not specific records. Is this something the Arrow is responsible for? Well, yes, but you're getting into an issue known as specificity. A right to know request needs to be specific enough so that the Arrow can identify what records are being sought. The analogy that I use is that a person can't come into your office and say, I want to see everything in that file cabinet. Rather, they have to be specific enough to say, I want to see everything in that file cabinet that's related to, and it could be, a project that the agency is working on. It could be, specific emails or so forth. You might want to talk to your solicitor about this. You might want to do a search on within our final determinations database on the term specificity, because this comes up quite frequently where an agency will say the request is not specific enough. You also want to refer to Section 701 or possibly Section 703. I think it's 701, where I'm quoting that language, or at least paraphrasing it, that basically a request has to be specific enough that the Arrow can figure out what it's for. Okay, because sometimes people, they're very vague with what they're asking for. And you have to be able to identify specific records. If you can't do that, there's the possibility that the request is not specific enough and you can deny it on that basis, on the language in Section 701. Okay, hopefully that addresses what you're asking for. And Gabrielle, that's somewhat advanced, okay, but that's a great question. Keep them coming. Okay, all right, so my point, just to reiterate, is that even though it might be on my personal smartphone or my personal computer, it could still be a public record based on the nature, the topic, the content of the message. Okay, then we come up to the second hurdle. And this time we have to answer the question, is it a public record? Okay, now notice the distinction. A record documents a transaction or activity of the agency. So if it does, we made it over that hurdle, we're still on the course. But now we have to determine, is it a public record? Is it something that can be released in response to the right to know request? Because we're saying everybody can look at it. But before we answer that question, there are three hoops that we need to get through. The first one is that, are there any exemptions that apply? And if so, are we going to invoke them? Now, what the heck is an exemption? Well, you would go to Section 708B of the Right to Know law, and you can download the law from our website, okay? And it's not a hard law to read. It's not a long law, okay? But Section 708B is this listing of definitions of records that the agency can release to the public, or they can withhold if they so feel there's a need to. And this is because, remember that slide where the right to know law is not a confidentiality law? The exemptions don't say you must withhold these records. Rather, they say you may withhold these records if you want to, at your discretion. And then you look at the exemptions themselves. They are basically definitions of types of records, where if the requested record fell in to this definition, the agency could withhold. For instance, there's one that says you can withhold a record if by releasing it, you would put someone in physical danger. Or there's another one that says if someone could use this record to compromise your computer system, you can withhold it. There's another one that says, well, for instance, if it's a health record for a public employee, you're not going to release that. So this exemption would apply. Anything related to a minor, okay, that would release information about a minor, you could withhold. Home addresses for police officers or judges. You look at, first offhand, there's 30 exemptions, and they cover an incredibly broad spectrum of records. And you'd look at each one and you'd say, well, yeah, of course, we'd never release something like that. Okay. There's a common sense factor here. Okay. But, it's at your discretion. Okay. Whether or not you would want to release them or not. The right to know law gives you that discretion. Okay. Question has popped up. I received a request for our general account. This account has our payroll. Do I omit employee name? No, you would not omit employee name. Public salaries, or the salaries of public employees, are clearly public records, okay? And it's always been that way. For instance, the state actually has a website. I forget what it's called. I think it's, oh gosh. Anyway, if you went to the main website for the state, you would find a link to a website that gives you all the state's budget information, and then there's another link that takes you to employee salaries, and you could search on a name and it would bring that up. Okay, so public salaries, including the names, are not confidential, they are public. Okay, other questions are popping up here, and we're easily going to go over an hour, folks, but that's okay. Hopefully you can stick it out with me here. Let me scroll to make sure I'm not missing any questions. Yeah, okay. Are copies of unaudited year-end fund balance reports public before they are audited and final adjustments made? I think there is language within the right to know law that would allow you to withhold that. Daisy, you want to take a look at the exemptions. I think this falls under, and it's been a while since I've looked at this, but 708B10, which deals with internal pre-decisional records. And I believe budget reports that have not been published or audited are included in there. But again, check that out yourself before you make any decisions related to that, or talk to your solicitor if you happen to be with us today on the agency side. Okay, then I have a request asking for copyrighted material. Oh my, okay. Great question. It's rather advanced, but I'm going to make this real quick. There is a Pennsylvania Commonwealth Court decision regarding copyrighted material. If someone submits a right to know request for records that have been copyrighted, you can allow them to view the records through the inspection provisions of the right to know request, of the right to know law, but they are not allowed to have copies of copyrighted material. Okay. we do another webinar, Michael. It's called Laws That Protect Information, and I spend more time on the copyright law and go into detail on the decision. It's Ali versus the Pennsylvania Housing Finance Authority, or I'm sorry, the Philadelphia Housing Finance Authority. Okay, where you can read the Commonwealth Court's decision on that. But I've given you the standard to use there. That's what we use here at the Office of Open Records based on that particular decision. Again, great questions. No harm in asking that. Okay, this is for our laborers as well. Okay, I'm not sure what that relates to. If you're talking about salary information, yes, all public employee salaries are public. The public has a right to know how much they're paying their public employees. Okay, there's no gray area there. Okay, that's black and white. Okay, yeah, all salary information is considered public. If hopefully that's what you're asking about. Yeah, good, good. Okay. All right, so let's get back to script here. Is it a public record? Okay, so we've determined that, let's say that there are no exemptions that apply. Pen watch, yes, that's the, okay, if you're concerning state employees and someone requests salary information for a state employee, yes, send them the pen watch. Thank you. I was having a senior moment here and couldn't remember the name of that website. If you want to know how much a state employee makes, go to PenWatch, okay? And that information is there. So you receive a right to know request, someone's asking for state salaries, send them the PenWatch and just give them the link to the website and you've satisfied the right to know request in compliance with the right to know law. Thank you, Eileen. Okay, now back to the obstacle course. So no exemptions, or if an exemption does apply, you've decided you're not going to invoke it. Now, the next question you need to answer is that, are there any federal or state statutes that make this particular record confidential? And if there is, that statute usually does not give the agency the discretion to release it, okay? It removes your discretion, and now you must withhold the record. For instance, employee health records. You've got, HIPAA, you've got the Family Medical Leave Act, you've got the Americans with Disability Act, all with provisions in them that say health-related information is confidential. You may not release it. And by the way, if you do, there's usually a sanction of some sort where you can end up paying a sizable fine. You get into police information where, under 708B16, yeah, you still have the option to release that information. But under another state law called CREA, the Criminal History Records Information Act, CREA says you may not release this information under any circumstances, or again, you face a sanction. Okay, so we do, like I said, we do a webinar on other laws that protect information. You might want to sit in on that webinar to find out what you can and cannot release, but that's where we're at here on the obstacle course. If there is another law that says this record is confidential, then you would use the provisions within that law to meet your legal burden to say, we are not granting your right to know request. Okay, so now we move on to the third hoop, where we need to answer the question, is this record protected by privilege? Here we're talking about attorney-client privilege, and it's mainly related to your solicitor. Your solicitor provides legal advice and guidance to your boards, to your supervisors, to your counsel people, and the like. That communication is protected by attorney-client privilege. Thus, and this is both supported by statute within Pennsylvania under the rules of evidence, as well as the right to know law, section 305, which specifically mentions privilege. So any communication like that could be requested through the right to know process would be denied because it's not public based on the rules of evidence in Pennsylvania and section 305 of the right to know law. Okay, but let's say it's not protected by privilege. Well, we've made it through the 3 hoops now, so we can jump over the second hurdle, which says this is a public record, and it ends up being released. The right to know request ends up being granted because it made it through the obstacle course. Okay, I need to go back to the other screen to advance. Yes, there we are. Okay, briefly, I want to talk about payment issues. And like I said, we do an entire webinar on payment issues, which I think is in 2 weeks, but I just want to cover some real basics here for your benefit. First, the agency is only required to provide the record in its current medium. This is defined in Section 701. And essentially what this means is hard copy versus electronic. So let's say that someone submits a right to know request and they say they want the records sent to them electronically. And they do this for 2 reasons. Number one, because it's easy, and number two, because it's free. You cannot charge for electronic records. But let's say that the agency only has the records in hard copy. They don't have an electronic version. Well, what Section 701 is saying is that the agency does not have to scan the records in, because that would be creating an electronic version of the otherwise hard copy record. You're changing it from hard copy medium to electronic medium, and you don't need to do that based on this language in Section 701. Okay, you do not need to scan records in if they don't already exist electronically. And like I said, you can't charge for electronic records if you do happen to have them electronically. Then earlier I mentioned, when we had the question about copyright, the inspection aspect of the right to know law. When a person submits a right to know request, they have 2 options. The first, most common, is I want copies. The second is that they have the right to inspect the originals. They can come in to the office and look at the original records. However, the agency is in the driver's seat as to when during normal business hours it is convenient for the person to come in and conduct the inspection. And the agency can supervise the inspection. You can sit there and watch to make sure that nothing gets altered, nothing gets destroyed or stolen, okay? However, if the person pulls out, like let's say a cell phone camera, and starts taking pictures, well, you've already said these are public records. They're allowed to do it. So they are allowed to take pictures. And again, there's case law to support this. Okay. As a matter of fact, they can bring in a scanner or their own copier to make their own copies, as long as it's not disruptive to your office operations. Okay. An agency cannot charge for labor. You can only charge for the copies that you're producing. You can't assess a redaction fee, and you cannot charge them for the cost of any legal review, whether it's by your in-house solicitor or some sort of outside counsel. You can only charge actual costs, like postage or something like that, that you can readily document. That's otherwise known as a pass-through cost. Okay, question has come up. Can they look at a document that is not redacted? No. And what this means, folks, a redaction would be where you've determined it's a public record, but there's some piece of data on there that is sensitive, like a social security number or a home email address, something like that. So you would redact that by blacking it out. Now, if you're showing them hard copies, you would end up printing that, making a copy. You can charge for the copy that you had to make in order to affect the redaction. Okay. But in this case, I strongly recommend, before you make the copy, reach out to the person and let them know that there's going to be a cost, because they're not expecting that and you don't want surprises. Okay, so let them know ahead of time so that they can decide whether or not they want to pay that money before you do the work. Okay. Another question's popped up. How do you protect personal signatures and information when you allow people to make copies with their own equipment? Well, you don't. I mean, a signature is a signature. And you're not violating any laws by making a copy of a signature when you release it. There's only a violation of the law if a person should happen to take that signature and misuse it in some way. But honestly, we've been doing this now for 13 years and this has never come up. So Dawn, while, I understand your concern, it's never been a problem. If someone's going to do something bad with a record that they received through the right to know law, they're going to get caught, but it doesn't come back on you with releasing a copy of a record that shows a signature. And oftentimes for legal purposes, you need that actual signature on the copy. So, it's not it's a valid concern on your part, but it's not one that actually has been a problem in 13 years of administering the right to know law. Okay? Are there limits to how much you can charge for pass-through costs? No, there's not. And we've actually had extensive pass-through costs based on particular scenarios. But again, you want to let the person know ahead of time what they can expect with any pass-through costs, just so they're not taken by surprise and so that you don't do a bunch of work and then they balk at paying for it. Okay, so the communication is good. And there's nothing in the right to know law that prevents you from having that communication. Okay, to talk more payment issues, I've said before, no surprises. Communication with the requester, or if you happen to be a requester, calling the Arrow and having a discussion with them about things like the costs is fine. And I recommend that. There's nothing wrong with talking to each other. Okay, now, payment, okay? The right to know law essentially says that records are provided upon payment. So what this means, if push comes to shove, you get the money first. The agency gets the money first, and then they provide the records. But I want to make something clear here. We talked about the deadlines. The deadlines, all throughout the right to know law, apply to the response, not the records. You provide the initial response within 5 business days. You provide the final response within the 30 calendar days, not providing the records. So you can grant a request within the deadlines, and you have to communicate that to the requester. We are granting your request for these records. But then you can say, and we will provide the records once you provide payment. And you can wait for the check to clear. And when everything is cleared, then you can say, here are your records. Okay, and that can be outside of the deadlines. There's nothing in the right to know law that speaks to a deadline for actually providing the records. It's subjective, but it's within a reasonable period of time, which is usually a couple days. Okay, just so you understand that distinction between the deadlines apply to the responses, not the provision of the records. Okay, then let's say that the response is going to exceed $100. Well, the right to know law accommodates that with what I call a security deposit. You take a quick look at the request, you realize this is going to be a big response and the costs are going to exceed $100. You can then reach out to the requester and say, send me a check for the full amount. And then we will begin processing your response. We'll make the copies, okay? And you can wait until the appropriate deadlines to provide the response that says we're granting your request, okay? But you can ask for the money up front before you begin all this work on what appears at face value to be a big response that's going to exceed $100. I like to define this as a security deposit so that you don't get stiffed for a bunch of money and a bunch of work and a bunch of copies if the person balks at payment after you've done all that. Okay. There's another provision called record discard, which I'm not going to go into, but in great detail. But basically, if you print a bunch of copies and the person either has or has not paid for them, you're only obligated to hold on to them for 60 days. After 60 days, you can destroy the copies and you've got nothing to worry about, okay? Because you've met your side of the obligations under the law. Okay, and then let's say that you have someone who submits a right to know request. You turn around and say, we're granting your request and we're providing you with the records, but then they never pay for them. Okay, well, let's say then that they submit another right to know request. Because that debt is outstanding, because they never paid for the first request, you can now deny any subsequent requests until that debt is settled. However, bear in mind that because it is a denial, they can appeal your denial. So you want to have all your I's dotted and your T's crossed that document the communication that you had, how you arrived at the costs, the calculation, 25 cents a page, et cetera, and so forth. Because when they deny it, or when you deny it and they appeal it, you bear the burden of showing why you denied it. And honestly, if you have all your I's dotted and T's crossed, the appeals officer more than likely will agree with you and say, yes, there is an outstanding debt, and until it's paid, the agency has correctly denied any subsequent right to know requests. Okay, so that's how that works. Again, if you go to our website, search the final determinations database, and simply put in the word fees, it will bring up all the decisions related to where the fees were disputed, and you'll get, a good flavor over the years as to how we have typically sided with agencies when they have correctly documented, how this debt was established. Okay. Denying access. Okay, we're getting close to the end here, and I promised I'd talk about appeals. But let's say that the right to know request has not made it through the obstacle course, and you've determined this is not a public record, so we're going to deny the right to know request. Well, a denial letter has to be prepared using a certain format. The first is that you need to describe the records that have been requested. Okay, well, you're thinking, that seems rather obvious, but it is surprising how many times a right to know request may not be as clear as it should be. So you put down, this is what we believe you're requesting. Then you put down the legal and factual grounds for your denial. Why isn't this a public record? This is probably the most important part of the letter because this is where the agency is meeting its legal burden. Okay, this is where you are meeting that fundamental part of the right to know law that says you must provide a legal case for any denial. So typically you would cite the appropriate exemption within the right to know law or the appropriate provisions using the other laws that make this record confidential or make it covered by privilege. Then you put down the contact information for the arrow because remember, this is the person legally responsible for responding to the right to know request. You put down the date of the response. This is important because there's another deadline that kicks in now. And then you have to outline the procedure for filing an appeal in case the person disagrees with your denial. And that is usually within 15 business days, you have to file an appeal with the Pennsylvania Office of Open Records, and you provide them with our URL for doing so. Okay, I'm going to pull up the next slide here, but then go answer some questions. Can adjustments be made for someone who can't afford the fees? Yeah, Tracy, that's going to end up being your own policy. I would just ensure that your policy is equitable in that it's not arbitrary in who you charge and who you don't charge. For instance, our office usually doesn't charge fees. Okay, some of these are advancing here and I want to make sure I'm not missing them. Oh, rats. Hold on, I just hit the wrong button. Okay, for some reason, it's not. Okay, next question I have, and I hope I'm not missing one here, is who can supervise the requester while they are reviewing records in the office? Well, usually it's the arrow, but it could be any employee for that matter. There's no limitation on who does the supervising of an inspection. Does non-payment matter if the right to know is different from the previous payment? Okay, I'm not sure what you mean there, but basically, if someone has established a debt by not paying for records that were requested and provided through a previous right to know request, then they turn around and file another right to know request. The same person files a right to know request with the same agency, and that debt is still out there from the previous right to know request. You can deny their current right to know request based on that outstanding debt. Okay, hopefully that answers your question. Okay, then another question. If the solicitor is answering the request, is the information and signature sufficient? Not sure what you mean there, Megan. If the solicitor is functioning as your right to know officer, is their information and signature sufficient? It's going to come down to if they are designated as an arrow. And a solicitor is considered a public employee for purposes of the right to know law. So you can actually have a solicitor appointed as your arrow if you want to spend the money to do that. Okay, most agencies will not do that, but there are some that have taken that step. Okay, now, good, now I got it to advance. Okay, Sue, okay, Megan Bamba on the response. Yeah, if the solicitor is responding on behalf of the agency, usually that's sufficient. You know, you're basically saying that your solicitor is the de facto arrow. I would prefer to have your arrow provide the signature, but again, you're not getting into any legal trouble if the solicitor signs on behalf of the agency. Okay, again, another good question, another good question. Okay, so back to the script here, appealing the denial. Like I said, the person has 15 business days to file a response. Now it's the OOR's business days, which is a Monday through Friday operation. Okay, so and now the obligation is on the requester who's filing the appeal, not the agency. So they just need to be aware of that. Okay, now I need to go back to this screen to advance the slide. There we are. Yay. Okay, so just so you know what an appeal is about, when we receive an appeal here at the Office of Open Records, we look for four things. We need a copy of the original request. We need a copy of the agency's response, provided they gave them one. The person needs to provide a statement then, why they believe the records are public and why they believe the agency's denial is inappropriate. If any of these four elements is missing, we issue what's called a deficiency order, and we give the person like 2 or 3 days to correct the deficiency. If they do, the case gets docketed, it gets assigned a number, and it gets assigned to an appeals officer, and we send out a notice to the agency, copying the requester as well, that we have an active appeal. And that notice usually is sent by email, but you know, if we don't have an email address for your agency, we'll mail it to you. But essentially, this is important. If you are with us today from the agency and you receive a notice of an appeal, do not run to your solicitor's office. And folks, this could be the most important piece of advice you receive here today. Everything I've described up to this point is what we'll call an administrative function. When someone files an appeal, it is a legal action. Basically, they are, for all intents and purposes, they are suing you. And at that point, the Office of Open Records, when it comes to dealing with appeals, we are what is defined by the Supreme Court of Pennsylvania as an independent quasi-judicial tribunal. meaning that our appeals officers are essentially a court. And everything needs to be done following certain procedures, certain protocols, using certain legal action or legal language, certain forms, et cetera, et cetera. And you don't want to lose an appeal based on a procedural error before we ever get to consider the merits. So do not try to handle an appeal by yourself. Run to your solicitor as soon as possible. Let them know we just got an active appeal, because they have very tight deadlines in which to respond to that appeal on your behalf. Okay, so run, do not walk to your solicitor's office. Okay, that's why I have it written in lead written in red in bold type and so forth. Okay, and basically the product of an appeal is a final determination, which is the ruling coming out of our office. If you've ever seen a decision coming out of your, let's say, your county court of common pleas, a final determination looks exactly the same way because it is a court decision. Okay, and you can find all of our decisions on our website in our final determinations database. You can go in and search on your municipality. You can search on a specific name. You can put in a random text string, and you can see what legal issues we've ruled on. And believe it or not, there's over 30,000 decisions in there. So chances are you'll find what it is you're looking for. Okay, also, if you have access to one of the legal websites or legal services like Lexis or Westlaw or whatever, all of our decisions get recorded there. Also, you can, if you have the docket number, you can Google it or whatever search engine you have, and chances are the decision will come up. There is the option of mediation, meaning when a person files an appeal, if they're interested in mediation, they can check the box. When we send you the notice that an appeal has been filed, we'll ask you, would you be interested in mediation? And if both parties are, we remove the appeal from the normal process, and it gets assigned to a trained mediator on our staff. Reason being, sometimes all it takes is a conference call, and you get the parties talking to each other and are able to come to an agreement. Usually that happens in about half the time. But it saves a lot of work for everybody. And if you're not able to agree, well, then it just gets reassigned to a new appeals officer and everything works out. Okay, but that option is available. Our decisions, let's say we issue a final determination and you don't like it. You can appeal it to a court. For a local agency, it goes to your county court of common pleas. For a state agency, it goes to the Pennsylvania Commonwealth Court. You have 30 days to do that from when we issue our decision. You have to notify us that you're doing it. And when you file your appeal, you do not list us as a party because we are the lower level decision maker. The dispute is still between the requester and the agency. They are the parties to the decision. The Office of Open Records will do one of three things. We'll monitor the case. We may file briefs if we believe there's some important point of law, or if we think it's a very important case, we may, in fact, request the judge that we appear before the judge. And we will send one of our litigation staff out to argue our points before the court. Okay? So we're at the end of the presentation. Yeah, we ran over, but I don't care. It's your fault because you asked such great questions. And I think that's awesome. Whenever you're asking questions like that, it tells me you're paying attention and that you're on your game here. I think you all at the local level are doing a fantastic job with administering your open records programs, because we see that here when we look at the appeals that we get. So, keep up the good work. If you have further questions, now's the time to get them in before I sign off, or send us an email to our office. Go to our website. You'll see that we have emails where you can ask questions, or you can call in, and the administrative staff will get you steered in the right direction. Okay. But barring any further questions coming in here, I just want to thank you for your participation today. We had a good crowd. We have what I like to call a hot bench. And that's when an attorney goes to court and there's a lot of questions. You know, the judges are firing back and forth. So you've been a great hot bench. Have a good rest of the day. Stay safe, stay warm. And like I said, in 2 weeks, another question has popped up. Yeah, Eileen, I detailed this at the beginning. If you want a recorded copy of the presentation, email in to the office and they will send you a link to the file sharing service where those recordings are kept. And yes, I did hit record before I started the session today. So do that, and that should take care of you. Okay, any other questions before I sign off, folks? Okay, I'm going to log out. Again, thank you for your participation today. Great time.